Hey, estate planning attorney Paul Rabalais here, and in this video we're going to talk about when not to use what I call and what I'll explain the small succession affidavit. All right, so the background is that, every day across America, every day across my state of Louisiana, unfortunately, people pass away and they pass away with assets. Might be bank accounts, might be real estate, might be vehicles. They pass away with assets that are titled in their name. And initially, after that person dies, the surviving family members don't have access to those frozen assets. And if that person who died lived in, or as we say, was domiciled in Louisiana, most surviving family members face having to hire attorneys like myself, and they have to go through that time and expense and of the court and attorney involved formal. Many people across America call it a formal probate proceeding. In Louisiana, we call it a succession proceeding. Now, some survivors of a deceased person who is domiciled in Louisiana, either because of what they see or read online or what they hear at the bank or the brokerage firm where there's a frozen account, they attempt to avoid the formal court proceedings by using what we call here in Louisiana the Louisiana Small Succession Affidavit. And I keep referencing Louisiana. In this video, we're going to focus on the Louisiana aspect of this Small Succession Affidavit, but it is particular to Louisiana. Perhaps your state may have something similar, so even by watching this video, you may learn something so that you can inquire properly into your state. But some survivors attempt to avoid the formal court proceeding by using this Louisiana Small Succession Affidavit procedure, where all the heirs sign these affidavits that certain requirements are met and certain paperwork gets recorded in the real estate records where the person owned real estate, or certain affidavits and other paperwork gets submitted to the bank or to the brokerage firm where the deceased had accounts. Or perhaps these affidavits are submitted to the Office of Motor Vehicles in an attempt to get a vehicle retitled that was titled in the name of the deceased person. So now the benefits of the small succession affidavit, it's a handy tool to have, because the benefits are, it's fast. There's no waiting around on judges and courthouse employees to process pleadings that lawyers have to get involved with to prepare. All of that stuff is eliminated with the small succession affidavit. It's easy. There's none of that court and attorney involved formal probate proceedings. In fact, many survivors kind of do that paperwork themselves. Some survivors, when they can and try to take advantage of the small succession affidavit procedure, some of them do hire attorneys like myself, particularly when there's perhaps real estate involved and certain things have to be recorded in the land records of the parish where the real estate was located. Some people do it themselves, some people get some attorney help. But so it can be a real savings on both court expenses and attorney expenses. But not every family is entitled to use this Louisiana Small Succession Affidavit procedure. So I want to go through maybe 3 scenarios where you cannot use this Small Succession Affidavit procedure. Number 1 is it's the biggest error that people make when using the Small Succession Affidavit. Our rules are clear. The affidavits that are signed by the heirs are all clear. That the small succession affidavit procedure can only be used when someone who was domiciled in Louisiana died what's called intestate, which means they didn't have a will or last will and testament. So sometimes, Freddie calls me up and, he's in a bind because there's something frozen out there and he can't get access to it. And so Freddie calls me up and says, Mr. Rabalais, I think I need your help. They told us at such and such place that Mama's such and such, we got to go through a succession and they need a letters testamentary or a judgment of possession or whatever it is that they told Freddie that he needs, which is going to be some type of court order. And then I'll say, well, Freddie, tell me a little bit about what your mother owned. And Freddie might say, well, you know, she had a savings account at the bank, but they told me at the bank we could all just, you know, do the small succession affidavit, and so we already got access to the bank account. And I'm like, well, Freddie, did your mother have a will? And he's like, well, yeah, she had a will. I got it right here in front of me. And then I'm like, you can't use the small succession affidavit procedure if there was a will. So, you know, and maybe Freddie says, or maybe somebody says, you know, we got the car title transferred already because they told us at the motor vehicle office we could use the small succession affidavit. We all signed it. We got the car transferred. So the problem is that all of the heirs sign these affidavits, these small succession procedure affidavits, and most heirs, I think, either don't read them or they're okay just signing affidavits that are untrue or incorrect. But whenever a small succession affidavit is completed by heirs, they have to sign the affidavit under penalty of perjury that there was no will. So just keep that in mind. All right, number 2. Even if there was no will, the small succession affidavit procedure still is not applicable if the deceased person who was domiciled in Louisiana had an estate that had a gross value in excess of $125,000. Can't use the small succession affidavit procedure, got to go through the formal succession or probate procedure, whatever you want to call it. So add up everything that the person owned. And again, it's the gross value. So if they had a home worth $175,000, but it had a $100,000 mortgage on it, that's still a gross value asset, $175,000. Even if they had no other assets, the small succession affidavit procedure is not allowable. So heirs, again, have to sign off under penalties of perjury that there's the assets of the deceased did not exceed $125,000. And then a third scenario where the small succession affidavit doesn't help you conclude all matters related to the estate is if just some third party out there just requires it, even if there's no will and even if there's less than $125,000 of assets. So for example, sometimes banks will say, well, your father had a safe deposit box here, and no one else has access to it. For you to access the content of that box, we're going to need a court order. So we've got to formally open the succession and formally get all the appropriate court orders to enable one or more of the survivors to gain access to that safe deposit box and get the content. So sometimes third parties require those court orders, and then you just have to go through the formal probate proceeding to get that third party, whatever it is that they got to have to enable you to have access to whatever it is that you need access to. But the emphasis here is on a couple of things. My primary points of emphasis are, number 1, smash the like button. That way, when you pull up YouTube, they're more likely to show you my videos than other videos that you may be watching, like cat videos. Number 2, if you haven't already hit the subscribe button, hit the subscribe button and the notification bell. That way you won't miss anything in the future. Number 3, just remember that if somebody who was domiciled in Louisiana dies, you can't use the small succession affidavit procedure if they had a last will and testament. And then also remember that if the gross value of the estate was in excess of $125,000, even if they had no will, you can't use the small succession affidavit procedure. And then my last point is the heirs, to complete that small succession affidavit procedure, the heirs must all sign under penalty of perjury that the information signed off on, including the fact that there was no will, the assets are under $125,000, the heirs sign under penalty of perjury that all that information is true and correct. So hopefully you're watching this video before you try to go through the small succession affidavit procedure when your circumstances really don't permit it. I guess in a real set of, there's always the problem that if families go through that and the person had a will, then those persons who received the money under the small succession affidavit, hopefully they didn't spend it, because they're going to be accountable to the heirs who are named in the will. So hope that helps. I think the small succession affidavit procedure is really overutilized and mistakenly utilized when it is not supposed to be able to be utilized. So be aware of that. Stay tuned to all my videos. I'm cranking them out. Keep up with your comments and everything else you got going on. We got some really great watchers out there. We'll see you next time.